Welcome to the 8th edition of World Intellectual Property Forum.
And welcome to my presentation on the World Intellectual Property Forum 2020 online and virtual seminar. Yes, my topic in this presentation is also going to be very much, or I mean say completely related to the online and virtual issues on intellectual property. Legal position on online conferences and meetings, and going live on social media and on the Internet of Things is my topic. Now, as you know, live streaming in any format, whether it be an online meeting, conference, lecturing, going on live on social media for fun, uploading your videos, streaming something in many ways you can, has now become a day-to-day part of our life. If COVID-19 has done anything, that is, it has got us more hooked into our online life, right? So the difference in this space is that it grasps with an ever-changing technology, and consequently the law grapples with the implementation and application of legal principles on a day-to-day basis. Now let's see how I can classify the broad-based legal issues on this. The broad-based legal issues online could be classified as copyright issues, defamation, hate speech, and the right to privacy and publicity. But for our limited purpose of intellectual property, I'm going to limit my presentation on the issues that comes up on IP. When it comes to using a device and videoing or filming something or clicking it, the location where you film or make that still shot is usually the biggest concern. The case of legality often comes in your location and the expectation of privacy of those around you. Generally, in many countries, if you are on a public property, it is probably okay. But again, there are exceptions to this rule as well. A street, as you know, is a public property anywhere in the world, but you cannot obstruct the traffic while recording it or taking a shot. Outside of a court is permitted to filming in many countries, but most countries, some countries, inside a courthouse you cannot. While a school is a public land, and there are many laws in most countries to prevent children from predators. So remember, if you are in a public place like a park, sidewalk, bus, member of the public in a bus or a train, you would have a reasonable expectation that you don't have privacy in those places. But this differs from country to country. Now, you all know that a person who takes a picture or record a streaming video or a video has a copyright to that picture or the video he took. But there are exceptional situations where you cannot use it although you have the copyright. Two of those main exceptions are, one is, although you have the copyright to that film or video, you don't have the moral right to edit, mutilate, interpolate or change what is inside it. That means a person without the consent of that person, right? Or if it's called copyrighted material without the consent of the owner of that copyrighted material inside that. The other exceptions are, actually there are two other exceptions. One is commercial use and criminal peeping. I'm not going to go into the criminal peeping area, but let's look at the commercial purpose issue. You can't use the picture or video you captured without the knowledge or approval of the person inside it for any commercial purpose. Now what does that mean? That means, so anyone featured on a commercial or promotional video content must sign a release form and generally be paid for it. The commercial entity otherwise can be sued for appropriation or misappropriation, as you call it, violation of that person's right to publicity and privacy. So basically, you have the right. So basically, you have a right to say whether you want to be associated with a product, a commercial product, or not. That's the principle behind it. Hence, when you are taking a video, you need to be careful filming other people and trying to put them on a commercial product, since this can raise these question of right to publicity which I just mentioned. The solution would be therefore to obtain consent if you're shooting films to be put on a commercial purpose, and get a release form, or get some friends who wouldn't mind being there, but whoever you put it in, make sure that you get a release form whether you pay or not, because otherwise people can change their mind and later problems can crop up. This is why, for example, in movie productions, in films, they use extras to stay in the background and pay them and release their publicity right. Also, one of the things you have to remember is photographing or recording someone in a private place or property is generally illegal. Now, I was talking about all this time public places. This is private places, and streaming their video on social media also is illegal, because it will amount to violation of their right to privacy rights, and would cause legal problems for you. So also you have to be careful when filming or shooting for a still shot, when even in the background there are copyrighted protected artwork, paintings, and even brand names of like in billboards. Now this is the reverse of what I told you just now. Earlier I told you about people, you're shooting random people and putting them in products. Here about you're shooting, and in the video or in the still shot, in the background there can be copyrighted artwork, paintings, or even brand names. So what will happen in a situation like this? Then the person who has the copyright for that whatever product, artwork, or painting, the artist, architecture, sometimes architectures, would want to claim against you if their artwork is showing in your video or photos without their consent or permission. And brands, generally companies, might send you a claim notice for using their trademarks or trademark registered, copyright registered in some countries, brands in your video or photo without their approval. This is because the companies would argue that your unauthorized use of their product or brand name or whatever on your video or picture may create a false impression or false endorsements of their brand, which they do not want to. So if you take it accidentally, remember there's one thing you can do. If you want to save that same video and you can't take the video again, you can blur those images before uploading or using it for commercial purpose. That's the only thing. But if you can, always better without blurring it, because it might distort your whole production. Get the permission from the people who owns it. And also remember, whatever I say here, whatever I said so far applies whether you shoot a video or picture and use them for your private collection, upload them on a site, including a social media site, or even if you're streaming. For all, it's not only for streaming and uploading in social. Okay, now let's move on away from filmed entertainment and filmed still shots, etc., to another area. That is about issues revolving around if you read a book online, blog post something, or playing a music in the background of your presentation. Now if there was music in the background of this, which I don't, or streaming something, some content, what are the issues that can generally come up? You may be, in most of these situations, when you even read a book or blog post or play music in the background, you may be in violation of someone's IP rights by doing that. So you have to remember is if you didn't create it, you don't have the right to use it without permission, and get a permission from the owner. Now there is what you call the fair use doctrine that applies here. The fair use doctrine is a situation where exception is created to copyright, but that will apply in this situation only for education, news, and training purposes, and you cannot apply the fair use doctrine for commercial purposes. The other thing that creates most of the issues is music, posting online, uploading, and streaming. Now there are several areas these issues are created. That is, this includes whether you have music in the background of a presentation like this or any kind of presentation, or you live stream on social media or upload them. But first, let me check out for you what is called a common misconception. That is, the misconception is if you buy a music CD, generally you think you have the right to upload it as well. Simple answer is you don't. Why? The right on the online space, or the Internet of Things we call it, is a different type of right, which is regarded as digital rights, and those rights are generally reserved and not given to you with music CDs which you buy. So the CD which you legally bought you will have rights to listen and play and enjoy, but the digital rights, streaming and uploading both, may have been reserved most of the time. In which case, your uploading is illegal and you don't have the as you don't have the digital rights. Similarly, also remember, you can't also download some music from a streaming site legally and re-upload in your site, because just like buying the CD, the streaming site or the downloading site may also give you the right to download, listen and enjoy, but not to reuse it or upload in your own social media site, or use it with other images and upload in anywhere, or stream it as a background. So both of them you have to remember as key. If you play music during an online presentation and you didn't get permission from that creator, any kind of music, you will be in all likelihood a violation of a copyright. I'm stressing this and repeating this again because that is something we generally do. The only exception here is if you download music that is royalty free, then you can use it for all your streaming, uploading or any kind of things like that. However, like everything else, this also has exceptions. What are those exceptions? Those exceptions are, most platforms buy what you call a blanket licensing rights from the rights holder or from the performance rights organizations, etc. So these rights are called mechanical licenses, agreement between owner and the rights holder. Mechanical license is a license user grants permission to release the audio format for interactive audio streams and digital downloads. Copyright societies do this kind of negotiations with social media sites, and if it is done in this kind of mechanical license clearance is given, then no problem. But if mechanical license clearance is not completed or is it pending, then that is a time that you will see when you try to upload some kind of a song, you will get muted in certain countries or in most of the sometimes the whole world. That is because mechanical license has not been cleared or is pending. In addition to this, there's another copyright issue, and actually it's a publicity and a privacy issue brought about by the artists, generally fledgling artists. The issue is here, the artist may not want you to use their voice or music or the song they played, and with some other images or in your background or anything like that, or your presentation. This is considered as distorting the artist's image or the artist's brand, because most of the artist brands are registered as trademark as well, and is regarded only he or she has the right to benefit from that image or brand. This is relatively new area, untested in this part of the world, in the sense where I'm coming from, Asia. But it appears that the fledgling artists would be on a strong legal ground wherever they saw this, should they decide to go after you if you were using their music for any kind of your productions or online streaming without their approval. The other legal argument musicians and bands of this brings in this kind of issue is that they can assert for unauthorized use of their music on social media for violation by way of confusion and dilution of their trademark. Like I said a moment ago, trademark, most artists register their trademark, their band or their name as trademark as well. So fledgling artists have trademark registration all over the world, and they will consider you're using their material as false endorsement, which implies that the artist does not support your product or your streaming or your broadcast. So you have to be careful in that. Okay, and there's another area called live event or another area called live event covering by streaming. This is another major area of violation, and also creates confusion among the right holders and the social media culture, which has brought about what you call the UGCs, the user generated content uploading and streaming. Now what happens here? The attendee at a concert, music concert, or a sports game or a conference all falls into the category of public. If you go live from a concert and share the concert music with your audience live streaming or recorded and upload later, you will be in violation of the intellectual property rights of the concert. This is because the venue may have cleared, generally they clear, secure a public performance right for the artist to come and perform there. But the same right has not been given to you, or no other right is given to the attendee to use that concert and live stream or record and upload later, right? That is the issue. But there are some very rare exceptions that certain social media rights, like I told you, the mechanical licensing situation, certain social media sites may get clearance, streaming or uploading clearance from such concerts as well, by way of clearing mechanical license. If you are lucky to find that kind of a situation, then if you stream live from a music concert, then your uploading will not be illegal. But this is a very rare thing. Social media sites don't generally get mechanical clearance from concerts. But there may be exceptions. Right. What about sports then? Now, if you go to a sports game, firstly, there are two types of sports you have to remember: purposive sports and aesthetic sports. Purposive sports is cricket, football, rugby, etc. Aesthetic sport is figure skating, synchronizing, swimming, and gymnastic, etc. So, what's the difference in copyright? What's the difference with regard to this type of sports when it considers intellectual property rights? The difference is this: purposive sports per se does not qualify for protection under copyright, but aesthetic sports does. Let me repeat: purposive sports per se does not qualify for protection under copyright, but aesthetic sports does. So what happens? So if you are in a purposive sports game, you can just take your device, whatever you have in your hand, a tablet or a phone or whatever, and use it, stream even the entire game from a stadium without their permission, and they will not be in violation of any kind of copyright. But you cannot do that if you are in aesthetic sports event. However, with regard to this purposive sports also, there are about 3 to 4 exceptions which you have to bear in mind. What are those exceptions? Firstly, you cannot live stream by holding your device to a TV screen and copying a transmission feed coming out of a broadcaster, even though it is a purposive sports. If you do this, it will amount to signal theft and signal piracy of the broadcast and by the streamer. Most social media platforms therefore will shut you down in situations like this. Second exception is if your entry ticket to the stadium prevents you from doing so under its conditions, you cannot live stream, because then you will be in violation of spectator ticket rules, contractual violation, which will amount the spectator gives the stadium right to even expel you. The third exception is if you are even still on a purposive sports event, if there's a song performed, then there is the same copyright issue which I mentioned with regard to a music concert. You cannot live stream that or record and upload. It will be in violation of copyright. And finally, if you're in France, remember purposive sports, you cannot do it, because in France, the French sports code sets forth a sui generis right. This right is similar to a copyright in that it gives ownership right to those persons creating the particular purposive sports and the right to control the exploitation rights of that work, which includes audio visual exploitation rights. So in France, you cannot live stream purposive sports without a permission, right? Remember again that on the other hand, if you are in an aesthetic sports event, you cannot live stream or upload as an attendee without copyright clearance being taken. Right, let's go into another area. What is this area? This area is something we all got involved in the last COVID-19 lockdown period, and we still are, I think, involved in that. That is a lot of online conferencing, presentations, studying, and privacy and publicity issues in that. Now, what happens? In most of the conferences, during the COVID-19 period, especially and even before, we found that there are a lot of business models, products, and other corporate secrets that have been leaked during conferences. This is the main issue revolving around online meetings and lecturing these days. So the problem arises to your privacy and IP. During this COVID time, we share our copyrighted material. That's corporate meetings, in seminars like this, lectures for students, etc., and participants of lecturer as participants and lecturers as presenters. These are the 3 ways that we share as participants, lecturers, and presenters. So most of these presentations are recorded, and the one who records has the copyright, as you know, generally. So what you need to do is, if you suspect they are recording, or generally as a general rule, you have to inform the person whom you are recording if you are the person who's hosting the meeting. And if you are the participant or the presenter, you should ask whether you've been recorded, and they should give the consent. If not, stealing copyrighted material, it will amount to stealing copyrighted material, because although you have the copyright of the recorded lecture, the content of the presenter or the lecturer, etc., are copyrighted material separately owned by that person, right? So that fixation issue can come up. So if you are a host of a meeting, simple issue is inform that you are recording it. And remember, not only copyright issue, a major issue of privacy can also come up there. Also, on business meetings, online conferencing, if an unpatented product or unregistered trademark is shown, that product can be stolen by the viewer, attendee, participant, or in an online meeting, or even if also on a business meeting, online conferencing, if an unpatented product is shared or an unregistered trademark is shared, the product can be stolen by the viewers or the participants on that meeting. And if the online meeting was unsecured, it can be tapped and hacked by a hacker as well. Which means even if you have consented the security of online platforms, you cannot be 100% guaranteed it won't leak your material. The sharing can happen by documents, video, or presentation share while online conferencing. So even if you remember, what you have to be careful is, if you show a product or talk about it, a business secret or something like that, the hacker or the participant can receive it, and if it is not protected by patent or copyright or trademark, depending on what it is, the receiver can do a lot of harm to you, register it under their name. And a further issue with regard to patent and trademark, as most of you know, is unlike copyright, the registration is territorial in nature. So if you have not registered in a region where you are making your presentation is going to, if it is picked by a hacker or somebody who is in the participants also, does they have NDA agreement before the meeting takes place, the participants in whose country it is not registered, they can steal and register it. And that's my presentation on the legal position of online conferences and meetings and going live on social media for the World IP Forum Virtual Online Conference 2020. Thank you so much for joining me, and I do hope all of us can meet in person on the World IP Forum 2021 soon. Thank you and have a good day.